someone to come testify? Recognize the gentleman from South Carolina.
Thank you, Mr. Chairman. I'm a lot more interested in having a balanced investigation than I am a balanced hearing. And in that light, Ms. Eckelbrett, did you hear the President say there was not a smidgen of corruption?
I've heard that he said that, yes, sir.
Ms. Garrison, did you hear the President say there was not a smidgen of corruption? And let me just translate that, because smidgen's not a legal term. I assume he meant scintilla, and I assume he meant criminality instead of corruption. How was he able to make that conclusion? Neither of you have been interviewed by the Bureau, have you?
No, sir.
And according to Mr. Sekulow, of his 41 clients, 3 have been interviewed, or 3 were asked to be interviewed.
Right. Not interviewed yet.
Okay. 0 of 41 have actually been interviewed.
Correct.
All right. So the President says there's not a smidgen of criminality or corruption. Do either of you remember seeing a witness named Lois Lerner sitting at the very table y'all are sitting at? Do you remember her invoking her Fifth Amendment privilege, the same privilege that she targeted some of your groups for trying to educate people about? Some of your groups just want to simply educate people about the Constitution, the one that she availed herself of the very second she was exposed to criminal investigation. So how can the President say there's not a smidgen of criminality when Lois Lerner invoked the Fifth Amendment? 41 witnesses haven't been interviewed, including the 2 that are here right now. How can he possibly draw that conclusion?
Good question.
I wish one of the colleagues on the other side of the aisle would ask the President how in the world he concluded no criminality when Lois Lerner sat in front of them and invoked her privilege against criminality. How do you square that?
Mr. Gowdy, if I may, she invoked her Fifth Amendment privilege, which she has the right to do, of course, and you and I both respect that, because we now know the reason why. It wasn't perhaps as clear as it was made yesterday. She invoked her Fifth Amendment privilege because she knew, after she made a false statement in a planted question at an ABA meeting, she knew that, in fact, there was her words and her emails, off-plan drafting of rules targeting conservative groups. She also said at a Duke Law Forum that people are asking us what we can do, and she said, I can't do anything until I see the 990s, the tax returns that are filed. That was all going on while she was redrafting the rules with the highest level of the Chief Counsel's office. Mr. Cartwright.
Mr. Sekulow,
yes,
I want to say this. I understand why she invoked her Fifth Amendment privilege. I don't understand why in the hell the President of the United States would prejudge an investigation
I don't either.
before any of your clients were interviewed, before either of these 2 victims, and I know you don't like that word, but I'm using it in the criminal sense of the word, before either of these 2 victims were interviewed. He has gone on national television, he has prejudged the investigation, and in my judgment has compromised the Department of Justice, which leads me to this question, Mr. Sekulow.
Yes, sir.
There is the option, when you have a compromised investigation and a chief executive who has prejudged the outcome before the jury's even gotten all the evidence, he's got an option of appointing a special counsel, right?
Yes, he does.
And the special counsel regulation says if it's extraordinary circumstances that furthers the public interest. Can you think of anything more extraordinary than government targeting people based on their political beliefs?
No, I agree with you 100%. And I also would point to the email of June 14, 2012, which was just released, because this shows the need for a special prosecutor at this point on the criminal aspect of this. And again, Mr. Cartwright, when you asked about the no evidence of politics, let me quote from the email. Don't know who in your organization is keeping tabs on C4s, but since we mentioned potentially addressing them off-plan in 2013, I've got my radar up, and this seemed interesting. These are coming from the most senior people within the Chief Counsel's Office of the IRS, which is a presidential appointee. Again, it's an office I came out of, so I have due respect for the office. But at this point, a special prosecutor to evaluate the criminal sanctions or criminal laws applicable would probably be the best, I believe would be the best way to go, because I don't think the Justice Department right now, again, with due respect to the Justice Department, is institutionally capable of doing this. And I need to say this also, because I thought that the question, Mr. Cartwright, on Ms. Mitchell's legal representation, she has an exceptionally excellent reputation in this town as a lawyer. And her clients tend to be conservative because that's who her clients tend to be. But, you know, I'm a conservative also, but like I said, I've represented the American Civil Liberties Union in cases at the Supreme Court of the United States. I've represented the National Democratic Policy Committee as well. So I don't think it's fair to go after the lawyers in a situation where it is the IRS that is trying to use their procedures to justify their illegal conduct. Remember the apology? They offered the apology. You know what? The apology is not accepted.
Mr. Chairman, in conclusion, I believe the ranking subcommittee member said that there are 13 people assigned to this investigation, if I heard correctly. 13 people in 6 months have not had time to interview a single solitary one of Mr. Sekulow's clients. 13 people in 6 months have not had time to interview either of these two witnesses, and yet the chief executive, the President of the United States, has already prejudged the outcome of this investigation. So either it's ongoing or it's not. Either he's wrong or Eric Holder is wrong. In either case, it is time for special counsel, Mr. Chairman.
Thank the gentleman. Recognize the gentleman from Virginia.
Thank you, Mr. Chairman, and thank you for this intriguing hearing. I will say at the outset, my friend from South Carolina, for whom I have great regard, we don't agree on much, but we have mutual respect. But I will say, it ought to trouble a Tea Party panel and a lawyer who represented the ACLU that this committee took upon itself a unique task in voting that a U.S. citizen, irrespective of her views or what you think she did or did not say, to protect herself against self-incrimination, a very sacred principle enshrined in the Constitution of the United States. And it was enshrined in there because of the experience of our founders with the British. It's a very real right. This committee took upon itself, every member on that side, including my friend from South Carolina, voted unilaterally to decide she dispensed with, waived her Fifth Amendment right. And if we can do that to her, we can do it to you. Every one of us on this side of the aisle voted not to do that because, irrespective of what one may decide on the substance of Ms. Lois Lerner's behavior, testimony, whatever, we think American citizens are entitled to constitutional protections, and that the Congress, a committee of Congress, does not have the unilateral ability to decide on its own that you waive that right. And listening to the testimony and the concerns here about a government that's overreaching, I would think you might be concerned about this committee overreaching. But it wasn't this side, Ms. Mitchell, that did it. It wasn't this. No, I'm not asking you a question. You made a statement. I'm making a statement. Ms. Engelbrecht, your written testimony states you believe various run-ins with the government were prompted by your applications for a tax-exempt status with the IRS. Is that correct?
Yes, sir.
One of the federal agents you mentioned is OSHA, the Occupational Safety and Health Administration. You complained specifically that in 2012, OSHA inspected your company, Engelbrecht Manufacturing, and which manufactures fabricated metal products, and you state that OSHA found, and I quote, nothing serious or significant, and nonetheless, OSHA issued fines in excess of $20,000. Is that correct?
Yes, sir.
OSHA's inspection report shows that it identified 10 violations at your manufacturing company, all of which it classified as serious. These violations included the failure to provide employees with appropriate eye or face protection when exposed to eye or face hazards from flying particles, molten metal, liquid chemicals, acids, caustic liquids, chemical gases or vapors, or potentially injurious light radiation. And, Mr. Chairman, I'd ask that the inspection report go into the record at this point.
Without objection.
Now, is it your contention that those findings were politically motivated because of your seeking a tax-exempt status for another entity? That those violations, in fact, were trivial or non-serious, in your view?
When OSHA came to our shop, They came under a false SIC classification. They came when neither my husband nor I were there, and proceeded to interview employees. And I would very much welcome everything that that OSHA
But my question,
gave to us be
Ms. Engelbrecht,
included,
my
because the
question was-
cover letter of OSHA clearly states
Ms.
that they
Engelbrecht.
found nothing. No, sir, let me please answer
No,
the
ma'am,
question.
I am going to control this questioning, and I'm asking you a simple question. You're going to have a press conference later. You can speak to your heart's content there. I only have 5 minutes. Were these or were these not, in your view, a serious matter? I thought your testimony said they were not serious.
In my opinion, and in the cover letter stated opinion of OSHA, they were not serious.
You complained that neither you nor your husband were there. Is it not the case that it's OSHA's practice not to give advance warning? That's the whole point of an inspection, to determine whether a facility, in fact, is safe, whether there are violations or not. To tell you we're coming next Thursday is obviously to give you a heads up to clean up whatever you might think is, a violation. Isn't that their normal practice?
Sir, I don't know what the normal practice is. We complied, as we did with every agency that came over these last 3 years.
Well, if it's your testimony now under oath that you don't know their normal practice, how are you able, nonetheless, to conclude that it's politically motivated and has something to do with your seeking a tax-exempt status to punish you for that, as opposed to their normal practice looking at a manufacturing facility to make sure it's safe for the workers?
Because in the past 3 years, after 20 years of being, nearly 20 years of being in business, and no agency coming to visit with us, the succession of agencies that have now come to us for all manner of things begs the question, the statistical probabilities of what happened to me happening without political motivation is staggering.
Well, I would just note for the record, Ms. Engelbrecht and Mr. Cicolo, because we're so concerned about the law here and making sure there are no violations of the law, are you aware of the fact that it's actually illegal for the Department of Labor's OSHA to give advance notice when it does inspections? That's actually a matter of law.
I was not aware of that, but I'm not contending that they should have given us notice. I'm only observing.
But you complained about it. You complained that you didn't get advance notice, and you just said you were concerned that neither your husband, I understand the concern, but you understand that they can't check in advance to see, will you be there?
Nor did we try to do anything to discourage that process, even though we weren't on premise.
And I absolutely take that at face value. But it's a huge leap then, given that, to conclude that someone's out to get you, Ms. Engelbrecht, that there's any political motivation whatsoever with OSHA following its standard operating procedures.
But, Mr. Connolly, you're aware that the information from the IRS is shared with other agencies. I'm sorry.
Mr. Sekulow,
Sorry.
I have not asked you a question.
Gentleman's time has expired.
Thank you.
Ms. Engelbrecht, in the first 20 years of business, did OSHA ever visit your place of business?
No, sir.
Never once?
No, sir.
After you filed the application, OSHA visited then, right?
Yes, sir.
Okay. And in the first 20 years of business, did the ATF ever come to your business?
No, sir.
Okay. And they came a couple times once you filed your application?
Yes, sir.
Right. And in your first 20 years of business, did the IRS ever audit you?
No, sir.
But once you filed your application, did they audit you?
Many times.
Okay. And in your first 20 years of business, did the FBI ever visit you?
No, sir.
But once you filed your application, did they visit you?
6 times.
But Mr. Connolly wants us all to believe that's a coincidence. I would recognize the... Go ahead. I was just pointing out that in 20 years of business, OSHA never came to Ms. Engelbrecht's place of business. Yes, I was. And in 20 years of business, OSHA never visited, FBI never visited,
Invoking my name,
IRS
Mr.
never
Chairman.
audited. Okay, well, you can respond. Even though I
Thank you.
gave you plenty of extra time, I'll give you some more.
Thank
you. Got the gentleman's recognized for a minute.
So where is the proof, though, other than your connecting dots that may or may not be connected, that OSHA was politically motivated?
I didn't say proof. I'm just saying you would want us all to believe it's a coincidence.
Oh, well, and you want us all to believe that by innuendo there must be something
15 times
wrong.
in a 2-year time frame, 4 different federal agencies visit this lady's place of business, audit her personal and business records, and you expect us to believe that just
I don't expect you to
Shazam,
believe.
it
I don't
just
expect you.
happened?
I don't expect you to believe anything. You can believe whatever you choose
well,
to
you
believe.
You can believe it's all a coincidence. I refuse to do that.
No, I didn't say that either. I believe in fact-based, empirical oversight. and innuendo and drawing conclusions and paranoia
Gentlemen,
do not substitute for fact-based empirical oversight, Mr. Chairman.
Well, here are the facts.
And McCarthyism.
She filed an application for C4 status and subsequently was visited by OSHA, FBI, ATF, and was audited by the IRS. That happened.
Mr. Chairman?
I would just say, Mr. Chairman, you should be on the panel given your views.
Mr. Chairman, will you yield your time for a parliamentary question?
Yield to the gentleman. Yes.
Thank you.
Gentleman's